Morning, everybody, and welcome to our webinar. My name is Elaine Hutley. I'm National Head of Employment here at Irwin Mitchell. And on behalf of Irwin Mitchell and our partners for this event, Michael Page, welcome. It's great to see some familiar names. I was going to see faces, but unfortunately, I can't see you all. Returning to our events, and welcome to anybody who is joining us for the first time. So as you can see, I'm not your only speaker today. I'm also joined by my fellow partners, Sibylla Steiner and Helen Kidd. And today we are going to be taking you through the Employment Rights Bill. We're going to be looking at 5 key changes that will be coming into force. So we'll be looking at unfair dismissal, exploitative contracts, harassment, industrial relations, and family related protections. Now, just while that slide is up on screen, if you're not already, please do scan the QR codes to connect with us on LinkedIn. We are going to be sharing a lot of information with you today, which is going to be relevant for the next couple of years for HR professionals. So as always, we will, over the course of the next couple of years, be sharing lots of updates as and when changes happen or consultations come into play, or as and when we know more detail about proposals. So that is the quickest way that you can get in touch with us. You can also subscribe to our email updates, and then you'll get invited to further events as well. And just before we get onto the content, we are going to be sharing a feedback form. So particularly with the changes that are coming into place with the Employment Rights Bill, if there's any topics that you would like to know some further detail about, or you would like us to do sessions on, please do let us know, because we do try to respond to your needs and what you want us to cover. And then finally, you can ask questions, so please do pop those in the chat. We have got a lot to cover, so if you could include your name and contact details when you ask a question, nobody else can see them other than us. If we don't get to answer them all in the session, we will try and come back to you separately afterwards. Okay, so without further ado, next slide, please, Donna. So just before we get into the detail of unfair dismissal changes, which I'm going to cover, let's just recap as to where we are. So before the election, Labour's proposals were set out fairly comprehensively in their plan to make work pay. And they were really brave in setting forth really wide-ranging proposals, and some of them were quite controversial. They've now published the Employment Rights Bill, which provides the legal framework for some of those key changes. And as I say, we're going to cover 5 of those today. We don't have all the answers, and a lot of information and a lot more of the detail is going to come out over the next couple of years. So what the Employment Rights Bill does is provide the legal framework. And if you think of that in the same way as you would build a house, an architect has drawn up the plans, but none of the foundations have yet been dug. That's the stage we're at the moment. So we have the framework, we know the topics that are going to be subject to change, but we don't yet know the detail. So what's going to happen is that there are going to be a number of consultations. Some of them already have been launched, and many are expected next year. Now, we can't do it justice in an hour. The bill itself is huge. It runs to 158 pages for anybody who's dived in to try and read it. We've also got a policy paper, which, as we mentioned on the slide there, is the next steps to make work pay. We have got a parliamentary statement, we've got government press releases, and there will be more documents to come in terms of codes of practice, etc. So let's have a look at unfair dismissal first. Next slide, please, Donna. As you will have seen from a lot of the press and a lot of the commentary, unfair dismissal is now going to be a day one right. And that means that all employees will be able to bring a claim of unfair dismissal from the first day of their employment if they are unfairly dismissed. So you'll still need a fair reason, and those reasons aren't changing. So the potentially fair reasons will still be conduct, capability, redundancy, illegality, and the catch-all of some other substantial reason. And we will still need to follow a fair process. But as you'll see from the slide, we've just included fair process ? And the reason for that is is that the bill has introduced the concept of an initial period of employment. So in other words, a probationary period, but this only applies at the outset of employment. So it won't apply, for example, if you've got an employee who moves into a different role, and then that new role is subject to a probationary period. The initial period of employment is when they first start work with you. And the commentary that we've seen so far is that during that initial period of employment, there'll be a light touch in terms of the process that you need to follow, unless you're dismissing for redundancy, and I'll come on to that in a second. So we don't yet know what that light touch process will be. So you will have to follow some sort of process, but hopefully it will be a little bit easier to dismiss someone during that period. So the government have said they have a preference for a maximum probationary period or initial period of employment of 9 months, which was a little bit longer than we were expecting, but that's not set in stone because it is subject to further consultation. Now, as I just mentioned, the light touch process won't apply to any redundancy dismissals. So if you are going through a redundancy process, you'll have to wrap anybody up who is employed with less than 2 years service in that redundancy process. So you'll consult with them in exactly the same way, but they won't be entitled necessarily to a redundancy payment. That 2-year requirement is still in place for entitlement to redundancy payments. Now, some of you might be sitting there thinking, well, if this is going to take, we're expecting autumn 2026 for this to come into force, will it be removed by a future government? You know, are we going to be stuck with this in the long term? And yes, we are, because they really thought about this change that they wanted to effect, and they have made it a permanent change in that they've repealed Section 108 of the Employment Rights Act. And what that means is, because that's been repealed, any future government can't easily reintroduce the qualifying period by introducing statutory regulations. They'd actually have to introduce primary legislation, which is much harder to do. So this is going to be a change that is with us for the foreseeable future. Next slide, please, Donna. So as I've said, it's a day one right. So an employee can't bring this claim before their employment has started, unless they're relying on one of the existing automatically unfair dismissal grounds. So nothing's changed in relation to those unusual cases, but to bring an unfair dismissal claim, they actually have to start. So the protection comes into place on day one. And in terms of the period during which you can affect the dismissal, as I've said, it's a light touch approach, but you have to give notice before the end of the probationary period, but notice can expire up to 3 months after. So it's not during that, if we say 9 months, because that's what we know for now, as long as you've served notice within the 9-month period, if notice expires afterwards, that is okay. And it's also possible, we think, or we expect, that you don't have to wait for the full 9 months. It should be possible, we are expecting, for you to be able to take a view earlier, say at 3 months, as long as you followed the light touch process. Now, there isn't any change to the time limits for bringing a claim. So it's still going to be the 3 months from the last day of employment, subject to any early conciliation. So there was talk that that would be extended, but that isn't the case. And we do still expect that the ACAS Code of Practice will apply to any dismissals or any dismissals that occur during the initial period of employment. But we don't know what the detail of that is going to be. And ACAS are going to have to review their guidance. And we don't know whether that's going to be a 2-tier approach where different rules will apply during the initial period of employment or not. So we're going to have to wait for the details on that. So, for example, we don't know whether someone who has been dismissed in the initial period of employment will have to be given the right of appeal against their dismissal. But as I say, follow us on LinkedIn, and as and when we know more, we will share details with you. Next slide, please, Donna. So as I say, we don't yet fully know what the light touch process will be because the details aren't set out in the bill. But we do have a little bit of an insight. So I'm going to get my crystal ball out now and tell you as much as I can. So in one of the documents, buried on page 37, the next steps to make work pay document, they have said, as a starting point, the government is inclined to suggest it should consist of holding a meeting with the employee to explain the concerns about their performance. So this seemed to suggest that whatever the code of practice will say in the future, the onus is still on that openness and transparency, in that you can't just skip straight to serving notice. There should be some sort of warning and explanation for the reasons. We don't know whether it will be expanded beyond that to say, and they also have to be given a further opportunity to improve. We will have to wait and see, but that will all be covered by the ACAS code when that is updated, and it will only be updated after the government have gone through a consultation process. And the good thing about the consultation process is anybody can respond to that. So you can. We are also considering whether for some of the consultations, we might want to hold some events, canvass your opinions and do a centralised response. So if you would be interested in that, in attending any of those events and feeding in your comments through us, please make a note on your feedback forms and we will invite you along to those. Now, some of you who are old enough to remember the statutory dispute resolution regulations back from 2004 are probably sitting there with a degree of cynicism, dreading the possibility that we might go back to that. Now, what we are hoping is that the current government will have looked at previous practices where there was the dispute resolution regulations, which was very, very prescriptive, and created additional litigation, that they're going to learn from those mistakes of the past and not reiterate them and not repeat them again. Okay, next slide, please, Donna. So as I've said already, we're not expecting the changes to come into force until at least autumn 2026. So there is lots of time to prepare and get house in order now with some really good practices, knowing that this is coming into force, even though we don't know the finite detail as of yet. So just some final top tips from me before I hand over. How should you prepare? First of all, I'd say have a look at your recruitment processes. So I would look to see what your retention rates are for new starters. And if you've got a high turnaround in some areas, it might be worth just reviewing your practices to say, is there any way you can make improvement to reduce the number of dismissals that flow in that initial period of employment? Because if you can get the right people in the first time, it's less likely that you're going to have to dismiss them, including during their probationary period. If you can mitigate against that risk as much as possible, I then turn to have a look at your processes and your procedures at the moment. So over the last couple of years, we have seen a trend where some employers have removed probationary periods from their contracts. You're going to have to reverse that and introduce a probationary period, not only as a contractual requirement, but also consider whether, for example, any of your line managers have got out of the habit of dealing with a probationary period or dealing with issues as early as possible, and documenting them and having those meetings to manage expectations. If they have kind of lost that skill set, you've got 2 years to work with them to put that skill set back in place and make sure they're being proactive, such that when the new requirement comes in, you will be as prepared as possible. And also, top tip, have a look at your diary management processes, because when the new initial period of employment is introduced, it will be really important for you to be aware of where employees sit within that period, to make sure that you do anything that you need to under the light touch process, and to make sure that notice is served before the last day of the probationary period. And so that is unfair dismissal, as much as you need to know for now, with a couple of tasks for you to take away. And I'm going to hand over to Sibylla now, who is going to tackle our next subject of exploitative contracts.
Thank you very much, Elaine, and welcome to our webinar today from me as well. I'm going to talk about exploitative contracts and the right to be offered, the new proposed right to be offered guaranteed hours and a right with regard to shift working. The government recognizes that variable hours can suit both workers and employers. For lots of people, obviously, zero-hour contracts suit their personal circumstances, and it gives employer also the flexibility to resource in order to meet fluctuation in labor needs. However, the aim of the government here is to deliver a baseline level of security and predictability for workers. As Elaine already mentioned, the bill is long and it is extremely complex, and that applies in particular to this new right to be offered guaranteed hours. What it in short means is that employer will have to make an offer of guaranteed hours to qualifying workers based on the hours that the qualifying worker actually regularly worked over a defined reference period. Now, what are qualifying workers? Those are workers on a zero-hour contract and workers, so-called low hours workers. What the definition of low hours worker will be, we don't know yet, but we will look at it in a little bit more detail on the next slide. What we also don't know yet is what the defined reference period, so the period that the employer will need to look at with regard to hours actually regularly worked will be. We think it is likely to be 12 weeks, but again, we will need to wait for regulations to have more detail with regard to that. It's also not clear yet what the level of regularity requires for hours actually worked in the reference period is. For example, does a contractual minimum have to be exceeded for only 6 weeks out of 12 or for 10 weeks out of 12? It's not clear yet. We will need to see what the regulations say. Equally unclear is what hours would I actually need to be offered. So would the guaranteed hours to be offered, are those the actual hours worked across the reference period? Or is it, say, a percentage? I don't know, for example, 80% of average weekly hours worked in the reference period. Again, we will need to wait for the regulations. Now, the obligation to make this offer of guaranteed hours is repeatedly triggered until the worker no longer qualifies for the right. So that means a worker doesn't qualify for the right anymore if they cease to be a low hours worker. So if an employee accepts a new or varied contract with guaranteed hours exceeding the low number threshold, then the employer will no longer need to monitor the hours and make further efforts. However, this cycle of reference periods will continue under certain circumstances, namely where the employer rejects the offer and instead opts to remain on the zero-hour contract, or where the accepted offer of guaranteed hours still falls below the minimum number of low hours. What an offer and acceptance will need to look like, again, will be set out in the regulations, but we already know that the offer must set out the days of the week and times on those days when the employer will make work available, or a working pattern of days and times. The offer has to be made after the initial reference period, which we're thinking at the moment is likely to be 12 weeks, and after each subsequent reference period, if the employee remains below the minimum number of low hours. If then more hours start to be regularly worked over time, then the subsequent reference period review will provide workers with the opportunity to reflect this in their contracts and to have even more guaranteed hours. Now, how this will operate in practice, again, is not entirely clear. And we don't know whether a recalculation is required at the end of every subsequent reference period, because there are very few references in the bill itself with regard to subsequent reference periods. In terms of timing, it is also not clear exactly at this point in time how long an employer will have after a reference period to actually make the offer, and how long the employee will have to accept or reject it. So whilst the bill does not ban zero-hour contracts, it does definitely give workers significantly more control. Because where high hours are regularly worked, it will be then the worker's choice as to whether they want a more stable or predictable contract. So for workers who are happy working on a 0 hours basis, they can continue doing so for as long as it suits them, although they will probably be pestered with regular offers after the reference period by their employer asking them whether they want a more predictable contract. If we could move to the next slide now, we will have a slightly closer look at what is likely or who is likely to be a low hours worker. Now, extending the right to low minimum hours workers is, of course, an anti-avoidance measure, because otherwise it would be easy for employers simply to put a worker onto a contract, say, for example, 1 or 2 hours a week. Then it wouldn't be a 0-hour contract anymore, and the employee wouldn't fall into the category of 0-hour contracts and wouldn't have the right to be offered a guaranteed hour contract. So that is the reason behind including the low hours worker in this bill as well. Again, what constitutes a low hour worker will be set out in regulations. And this is, of course, the critical question. Because if it is set too high, then that will severely limit businesses' ability to adjust staffing levels on short notice, and also increasing an administrative headache because more workers will be brought into scope. Setting it low, so for example, if it is only 2 or 3 hours work a week, then the legislation might not have that much impact. But for example, if a low-hour worker is someone who, say, works 12 hours a week, then that will affect many more employees and many more employers. Once an employee, as I said when we had the previous slide as well, once an employee falls out of the definition of a low hours worker, then these provisions won't apply anymore. Again, as Elaine mentioned when she talked about the day one dismissal right, we'll obviously keep an eye on developments here. And yeah, if you follow us on LinkedIn, you will see our regular updates. If we could move to the next slide now. And we will have a look what this offer of guaranteed hours actually means. Now, the default position is that any offer of guaranteed hours will need to be for a permanent change of terms and conditions. However, that may not be feasible for employers where the reference period has included unusually high levels of work, and there are expectations for when the work is inherently temporary. So that applies, for example, in the retail hospitality sector just before Christmas, where many hours are worked, and possibly seasonal workers as well, when it comes to fruit picking or harvest time. Now, the bill attempts to address the question of short-term labor, and it sets out circumstances where it will be considered reasonable, and please note the word reasonable, to make an offer for a limited term contract instead. Now, limited term contract is the reference, or is the phrase used in the bill. What's meant by that is a fixed term contract. And according to the bill, they can be offered where reasonable and where there is a limiting event. And a limited term contract is likely to be reasonable if an employer reasonably considers that the worker is only needed to perform a specific task, and the contract provides that it will be terminated when the task has been performed, where the worker is only needed until the occurrence of an event or failure of an event to occur, and where the contract provides that it will be terminated on the occurrence of the event, or that there is only a temporary work need and the contract provides that it will be terminated when the employer reasonably considers that that need has come to an end. The example given here is providing cover for another worker. But the circumstances are quite broad, and they could arguably, therefore, extend to seasonal fluctuations in work, as I mentioned earlier, peak retail hospitality periods in the lead up to Christmas. So, for example, if a retail worker has a very busy initial 12 weeks in the lead up and over Christmas, the offer of guaranteed hours will then need to reflect those hours. But if the retailer expects a sharp decline in custom because Christmas is over, then it seems possible that they will be able to offer a limited term contract. Aside from the many points in this part of the bill that will be determined by regulations, and I've mentioned that many times now, the crucial question of reasonableness, however, is a bar that is to be set by employment tribunals in the future. So we are not expecting any definition of reasonableness to be dealt with in any regulations. There will be no need to make an offer for guaranteed hours where the worker is fairly dismissed or where the worker resigns during the reference period or the offer period, so before an offer is made. And similarly, there will be no need to make an offer if a limited term contract, so a fixed term contract, ended because of a specified event. So if the contract is only for that specified event, a fixed term contract, say for being in retail as sales assistant up until the 24th of December, then there is no need to make an offer of guaranteed hours after that. Now, this arguably leaves the worker worse off, as they will not revert to any previous 0 or low hours contract. So if there is a resignation or a dismissal during the response period, then the offer will be treated as withdrawn. So after an offer is made, but there is a resignation or there is a dismissal, then the offer will not stand and will not apply anymore. A worker, so what rights does a worker have if they are not offered hours on the required terms? What they can do is they can bring an employment tribunal claim. The bill currently refers to a 3-month time limit within which that claim will have to be brought. But it is worth noting that the government actually plans to amend the bill to extend time limits more generally. So again, keep an eye on that. If the claim is successful, then the tribunal must make a declaration and must also make an award for just and equitable compensation based on financial loss. Now, in practice, this is likely to be based on the guaranteed hours that should have been offered, but the usual rules about mitigation would also apply. The maximum possible award will be capped. Again, what the cap will be set out in regulations. And also workers, please note that workers will have a right not to be subject to detriment because they accepted or rejected any offer. If we could move to the next slide, please. I just wanted to mention here that although I've just said that workers have a right not to be subject to detriment because they accepted or rejected any offer, and although in the longer term the government plans to remove the distinction between employee and worker, at the moment, for now, only employees will have the right not to be unfairly dismissed because they accepted or rejected any offer. So an employee who is dismissed for accepting or proposing to accept or rejecting or proposing to reject an offer will be considered to have been automatically unfairly dismissed. So this would add a significant additional burden to employers. If we could go to the next slide, please. This, again, is not likely to come into force before 2026. So what can you do as a business to prepare for this right to be offered guaranteed hours at this point? The first thing we would suggest is to have an audit so that you are sure and you know exactly how many people you engage on 0-hour minimum hour contracts, and that you also start considering how the reference period provisions are likely to apply within your organization. So as I said, at the moment we are expecting the reference period to be 12 weeks. And how can it be done that the hours that are actually worked in practice are properly tracked? Because that will be of significant importance in relation to the right to be offered guaranteed hours. If we could move to the next slide, please, and we will have a look now at the right to reasonable notice of shifts. Now, with regard to that, the bill introduces a right, basically three new rights. So the first right is the reasonable notice to shifts, and that provides to shifts that the employer requests or requires a worker to work, and that includes if a shift deviates from a shift pattern that is referred to in the worker's contract, and the notice must include the day and the time of the shift as well as how many hours are to be worked. The second right is the reasonable notice of shift changes or cancellations. And the third right is the payment for cancelled, moved, or curtailed shifts. So that third right creates a duty on employers to make a payment to workers each time that a shift is cancelled or moved or curtailed at short notice. The payment does not need to be made in specified circumstances, but what these circumstances are likely to be, again, is not clear at this point. If specified circumstances apply and therefore payment isn't necessary, the employer must give the worker a notice explaining why they believe that the payment is not needed. So what is reasonable notice? Again, it will depend on the circumstances. The regulations will set out a specific minimum time before the shift is due to start. If less notice is given, it will be presumed to be unreasonable unless the employer can show otherwise. And again, determining what is reasonable will be done by the tribunal, and what they must have regard to is a number of matters which will again be set out in the regulations. What these matters are that are considered to be relevant, we don't know at this point. If we could move to the next slide, please, and we will have a quick look at to whom this right to reasonable notice of shifts will apply. So similar to the right to be offered guaranteed hours, it will be provided to 0 hours workers and those on 0 hours arrangements, as well as workers on low hours contract with some guaranteed work. However, these rights are also likely to apply to a broader category of workers, including workers where the employer is required to make some work available, but does not specify the days or times that need to be worked. So this will likely include shift workers with a variable working pattern. However, we will need, again, sorry, I'm sounding like a broken record. We will need to wait for regulations to find out what types of contracts would fall within or would fall within this protection beyond 0 hours and low hours worker. The bill does include powers for the regulations to specify that the provision only applies to contracts which are below maximum salary or below maximum hours number of guaranteed hours. So again, we will need to see what the regulation says that these amount of hours could be. This right does not apply to agency workers. And this is my part of the webinar finished in relation to exploitative contracts. And I'm now handing over to my colleague Helen Kidd to take us through the rest of the presentation. Thank you.
Thank you, Sibylle. So next slide, please. I'm going to take you through now three of the final areas where we're going to see some changes in respect of the Employment Rights Bill. So firstly, harassment, and specifically the additional changes that we're going to see around sexual harassment and third-party harassment. So the Employment Rights Bill is going to bring in some additional protection for against sexual harassment in the workplace. As you'll be aware, at the end of last month, on the 26th of October, the new legal duty on employers to take reasonable steps to prevent harassment of their staff from being sexually harassed in the course of their employment came into force. Now, that duty requires employers to anticipate when their staff are most likely to be at risk and to take steps to prevent against that risk. We've developed a free toolkit to help employers with this new duty, and the toolkit includes a free sexual harassment policy. So if you haven't seen this and you'd like to receive a copy, then please do make a note on your feedback form today, and we'll ensure that that's sent over to you. We've also developed training for employees and for line managers, and we now have snippets of that training available on our YouTube channel. So again, please let us know if you're interested in this training in your feedback form, and we'll send you those details. So in terms of the Employment Rights Bill, well, it's going to strengthen this legal duty to prevent sexual harassment in the workplace even further. And what it's going to do is it's going to require employers to take all reasonable steps to prevent sexual harassment. The bill will give the government the power to set out in new regulations the steps that would be regarded as reasonable for the purposes of meeting that obligation to take all reasonable steps. Now, what we know from existing case law is that to be able to demonstrate that you've taken all those reasonable steps, you must effectively have taken every reasonable step available to you, even if that step in question wouldn't have prevented the harassment in the first place. So if an employee can point to a step that you could have taken but you didn't take, and the tribunal decides that step was a reasonable one for you to take, you'll be held vicariously liable for the harassment that the employee has suffered. What the Employment Rights Bill is also going to do is also going to provide that an employee who makes a disclosure to you about sexual harassment will be protected under the existing whistleblowing regulations. Donna, can we move to the next slide, please? Okay, so in terms of third-party harassment, under our existing legislation, it can be difficult for workers to bring successful third-party harassment claims against their employers if they experience that third-party harassment by a customer or another third party whilst at work. The Equality Act used to provide specific protection for third-party harassment, but those provisions were repealed back in 2013. What the Employment Rights Bill is going to do is going to reintroduce liability for employers where their staff have been harassed by a third party in the course of their employment. Now, that wording "in the course of their employment" is very wide. What it means is it's not limited to the office itself, the factory floor, the shop, etc., or the place where the person actually works. It'll also include, for example, electronic forms of communication, so emails, text messages, WhatsApp messages, etc. And employers are going to be liable for any type of third-party harassment linked to any of the 9 protected characteristics, so not just sexual harassment. And you'll only be able to successfully defend claims if you can show, again, that you've taken all reasonable steps to prevent it. Now, the difference between taking reasonable steps and all reasonable steps is pretty significant, because as I said before, with all reasonable steps, you have to show that you've taken every reasonable step that's available to you. And again, if an employee or a tribunal was able to point to a step that you could have taken, but you didn't take, then you would be held vicariously liable for the harassment that the employees suffered. So that's a very difficult test for even the larger employers to meet. So it's something to be on your radar. So in terms of third parties, who could they be? Well, they can be customers, clients, patients, service users, people's friends, relatives, and so on. And third-party harassment under the Employment Bill will apply from the first instance of the harassment. So previously, employers were only liable if there had been 2 or more prior incidents of harassment, but now it will apply to the first incident. And obviously risks can be higher in specific sectors, so where alcohol's involved, so potentially in the hospitality sector and also in education. So next slide, please. Okay, so how can you prepare for these changes? Well, we'd recommend that you expand your sexual harassment risk assessments to include the risk to your staff of being harassed for any particular reason. Now, our toolkit also includes a template risk assessment if that would assist, but again, make sure that those risk assessments are extended to cover third-party harassment. We'd also recommend that you assess where your staff are most likely to be at risk and consider what things you can do to prevent that. So putting up notices, recorded meetings on internet, etc., and warnings to staff and line managers alike. We'd also suggest that you ensure that your policies and procedures include third-party harassment, and that your staff know how they can report incidents and what they do if they are subjected to any harassment whilst in the workplace. You should review your arrangements with your customers and your clients, suppliers, distributors, etc., to ensure that their terms of business specifically also include the prohibition of third-party harassment. And you should expand your training for employees and line managers to include third-party harassment of any type, so not just your sexual harassment training that you may already be undertaking. And finally, ensure that your leaders and your managers in your business can step up. They'll have to warn third parties, and in some instances, they may have to ban them from particular organisations. So next slide, please. So moving on now to industrial relations. In terms of trade unions, and as can be expected with a Labour government, there are lots of changes coming. So the Employment Rights Bill is going to repeal most of the Trade Union Act 2016, which made it more difficult for trade unions to take industrial action. It made it more difficult for them because it imposed higher ballot thresholds for certain public services. It required trade unions to reballot members after 6 months, and it restricted picketing. So that's going to be repealed. And also, the Employment Rights Bill is going to revoke legislation that the Conservative government brought into force just last year, which is the Strikes Minimum Service Level Act 2023. As you may recall from one of our webinars last year, that act required businesses to ensure that a certain number of people stayed in work during industrial action to meet minimum service level requirements for specific sectors like the health service, the fire and ambulance service, and border security. So what the Employment Rights Bill is going to do is going to make it easier for trade unions to call strikes and to get access to the workplace to recruit and reorganise their members. Now, the big change that the Employment Rights Bill is going to bring in is it's going to require employers to give their staff a written statement on or before the first day of their employment that they have the right to join a trade union. It also says that you'll have to give them a written statement at other prescribed times throughout their employment, although other prescribed times is not yet defined. The Employment Rights Bill will also provide additional protection for employees who take industrial action. So currently, an employee who takes part in industrial action is protected against dismissal for a period limited to up to 12 weeks only, but only if not if their employer suspends or disciplines them in an attempt to deter them from taking strike action in the first place. So what the Employment Rights Act is going to do is going to enhance that protection further by protecting employees engaged in lawful strike action from being subjected to, one, a detriment for taking part in industrial action, and two, from being dismissed from taking part in industrial action for the entire duration of the strike and not for just that 12-week period. Okay, next slide, please, Donna. Okay, so changes to collective redundancies. So currently, employers proposing 20 or more redundancies at one establishment within a period of 90 days or less must collectively consult with either a trade union or employee representatives before making anyone redundant. If they don't, employees can claim a protective award for up to 90 days actual pay. The Employment Rights Bill is going to remove those words at one establishment. So what that means for employers is that employers will need to count any proposed redundancies at any of their sites or premises when determining how many employees are involved and therefore whether they need to start collective consultation. And that will include counting people who work from home. The government has also launched a new consultation on increasing protective awards. So it's currently considering two options. Firstly, whether to increase the length of the award from 90 days to 180 days actual pay, or to remove that cap entirely and put the power back in the tribunal's discretion to award such amount as they deem just and equitable, depending on the severity of the breach claimed and proven. More radically, the government's also considering whether it should allow employees who are able to claim a protective award the ability to claim interim relief. What that would mean would that employers would have to re-employ the employee or pay them their salary and benefits until a tribunal reached a decision on the merits of their claim. So that's a pretty radical proposal. And next slide, please, Donna. So finally, changes being introduced in connection with family-related leave. Well, the Employment Rights Bill is going to introduce additional protection from dismissal in connection with family-related leave. The detail here is, however, very, very limited, so that's why we've only got a short slide in this regard. So currently, as you'll know, in a redundancy situation, pregnant women, those on maternity leave and those returning from maternity leave within 18 months of their expected week of childbirth have the right to be offered a suitable alternative vacancy ahead of anyone else who has been provisionally selected for redundancy. And similar rules apply to new parents returning from adoption or shared parental leave. The Employment Rights Bill is going to extend this protection further to dismissals for reasons other than redundancy, although at the present time we don't know what those reasons are going to be. And it's going to be for a period of time after the return to work. Again, the Employment Rights Bill didn't specify what that would be, but the accompanying explanatory notes did suggest a period of 6 months here. And they also said that this would be except in limited circumstances, but again, they haven't defined what those limited circumstances would be. So there is a lot awaited in respect of these additional protection for people returning from family-related leave. What we do know is that the additional protection is going to apply to employees taking all types of family-related leave that we currently have, like adoption leave and shared parental leave, as well as maternity leave. But it's also going to include forms of leave which are not even yet in force, so such as neonatal care leave. So I'll now hand back over to Elaine, and she can explain how you can keep up to date with all the changes that we've covered in this morning's session.
Thanks, Helen. We're running really well to time, which doesn't always happen, as some of you will know who attend our webinars. Sometimes we try and fit in a bit too much, but we have got time for questions, but we have had lots and lots of questions. So I'm going to try and summarise them. But just before I get onto those, as I've said, if you connect with us on LinkedIn, if you put a note on your feedback form, if you're not subscribed to our updates already, we want to keep in touch with you over the next couple of months, because as you can see, there's a lot to get your head around, and we try and help you with that as much as possible. So if we could just, Helen and Sibylla, I'm just going to bring you back on screen to try and run through some of these questions that we've had in, and we've had some similar themes, so I might paraphrase some questions that have come in. Helen, just running off the back of yours, someone just asked, could you just please explain what you mean by protective awards for those who haven't come across them before?
Okay, so protective awards. So if you haven't met your requirements to collectively consult in a redundancy situation, so if you're making 20 or more individuals redundant, you have to collectively consult. If you fail to do that, employees can claim what's called a protective award, and it's an award of pay for up to 90 days pay, actual pay, for that failure to have protected them in that collective redundancy situation.
And that's in addition to any awards that they might get from fair dismissal, so their basic award and their compensatory award. So it's a bit of a penalty, really, isn't it, Helen, on employers for not complying with the duty to consult?
It is, and it's in addition to the statutory redundancy payment that they'd also be entitled to as well.
Yeah, perfect. I'm just picking out some questions. So just in relation to the initial period of employment or probationary period, there were a couple of questions that came in to say, is it possible during that period to still follow the disciplinary policy as well as the probationary policy? And is it possible to extend a probationary period? So I'm just going to pick up on those. So yes, absolutely. You'll have a probationary period, or you'll have a probation policy potentially, or a clause in your contract. during that period, it doesn't mean that you can't use your disciplinary policy with employees. So if you have a new employee who commits an act of gross misconduct, of course, you would refer to your disciplinary policy and the expectations that are set out. But I think it's important to just bear in mind whatever policies you have or whatever policy you have that sits side by side with your contract has to be dovetailed. So it's just a matter of looking into the detail. And then in terms of can you extend a probationary period, I think this will depend on, one, where we are left in terms of the initial period of employment, which will be statutory, and there won't be an ability to extend that. That will be a period during which this light touch process applies. If within that initial period of employment, you also want to have a contractual probationary period that's shorter, that says internally you will review someone's employment on a monthly basis or 3 months to 6 months, you just have to make sure they're consistent and they don't contradict. So what will be set in stone is the statutory initial period of employment. How you want to deal with that contractually, as long as it's compliant with the statutory provisions, is a matter for you. And once we know more detail, we will work with clients and contacts to talk about how you want to manage that. So hopefully that answers the questions on probationary periods. Sibylla, I'm just going to come to you now, because we have had lots of different varieties of questions, but in terms of guaranteed hours contracts and whether they would apply to agency workers as well as employees and workers. So can you give us a bit more detail on that?
Yes, of course. There is actually currently a government consultation about whether the application, whether the 0-hour contract measures should also apply to agency workers. And the views that the government are seeking there is how these new employment rights should apply to agency workers, agencies, and potentially umbrella companies as well, if they are used, and also to the end hirer. The consultation opened at the end of October, and it will close at 11:59 p.m. on the 2nd of December. It's an open consultation, so you will find it on the government website if anyone would like to put forward their views with regard to these exploitative contract measures, whether they should apply to agency workers or not.
Brilliant, thank you. And then there were also some questions around where businesses are using 0 hours contracts for short periods. For example, we had a question about exam invigilators, or where there are seasonal peaks. So people might use university students for a few weeks, and then the students will go back to university, and then they might come back in their next break. So can you just give us a little bit of detail on that?
Yes, so I think what we need to distinguish between is if we have a sort of open-ended 0-hour contract, and if based on that there is a fluctuation in the hours that are worked, then the right to be offered guaranteed hours would apply to that contract. Where we only have a fixed term contract or a limited term contract to start with, then that fixed term contract would end when the particular event or the exams or whatever have come to an end. And so, as I mentioned when we looked at that particular slide, where there are fixed term contracts to start with, that would be detrimental to the employees, because after the event, after the fixed term has ended, there isn't any 0 hours contract anymore.
That's great, thank you. And then Helen, we've just had quite a few questions actually. I think quite a lot of people who have joined us today are nervous about trade unions and increased activity. So we've had a couple of questions to say in terms of the statement that we're going to have to give to employees on their rights to join a union. Can this be within the contract of employment or their section 1 statement, or does it need to be a separate document? And a second run-on question say, does that apply to companies even if they don't recognise a union at the moment?
Yes and yes. So it should be within your Section 1 statement. It has to be a written statement given on or before the first day of employment or this other prescribed period, which the government hasn't defined yet. So we would suggest the best place to put it would be within your Section 1 statement or your contract of employment. And yes, even if you don't recognise a union, you would have to say in there that the employees have the right to join a union.
Brilliant. And then I've just got one eye on time, so I'm just going to do a very quick wrap up. So we've had a few questions around harassment and the all reasonable duties, what that means, how to prevent third-party harassment, and around WhatsApp. So as Helen mentioned, we do have a toolkit, and some of these questions will be covered in that toolkit. So please do, on your feedback form, make a note if you want us to send you that. And then, of course, if there's any further questions that aren't answered in the toolkit, please reach out to us. You'll have our contact details, and we're happy to talk to you both about the duty that's coming in October, but also how that's going to be expanded in the future and how you can prepare for that. So that is it for time. I'm sorry we haven't had a chance to answer all the questions, but what we will probably do, in fact, what we will do, I'm going to commit to it now, is to theme the questions. We won't use them specifically so that anybody can be identified, but we'll do a follow-up of just some of the questions, themes that have been answered with some some of the questions that have been asked with some answers, and we'll share that with everybody. If you would like a copy, please make a note on your feedback form and we'll make sure. But if you do have anything more specific to your business that perhaps you didn't want to share today, please do reach out to us, because we are here to help. And then Donna's kindly put up on screen just a reminder of how you can keep in touch with our newsletters. We do blogs via Passel if you connect with us, and we also have a podcast series. Please do finally let us know if there's any topics you would like more detail on, and we will try and build those into our events programme. But just one final thank you to Donna and our team behind the scene, who have done a sterling job of keeping us on track today, to my fellow speakers, Sibylla and Helen, and thank you all for attending and sharing your questions with us. Thank you all. Have a good day.